Rights to intellectual property, an introduction and examples and its Indian context. Do you wish to work on software or mechanical patents? Dispute artistic or musical rights? Or advise business clients on how to safely license their content? There are numerous profitable industries in the sphere of intellectual property rights. Discover the definition and usage of intellectual property law as well as the many functions played by IP lawyers. What does the term intellectual property rights mean? Intellectual property rights are any and all rights connected to intangible assets that are owned by a person or business and are safeguarded against unauthorized use. Non-physical property, such as the right of ownership over intellectual property, is referred to as an intangible asset. Intellectual property rights include the following examples: domain names, patents, industrial style, patents that include sensitive information, moral principles, database rights, authorship works, a service mark, logos, trademarks, rights to designs, trademarks or company names, commercial espionage, computer programs. What kinds of intellectual property are there? Intellectual property rights fall into 4 categories: patents, trademarks, copyrights, and trade secrets. To protect the same intangible assets, intellectual property owners sometimes combine many of these categories of intellectual property law. For instance, copyright law protects a product's tagline whereas trademark law just protects its name. 1. Patents. Original inventions, including methods and devices, are granted property rights by the U.S. Patent and Trademark Office. Patent law grants one or more inventors exclusive rights and shields creations from unauthorized use. As seen by the patent on the first computer, technology businesses frequently employ patents to safeguard their investment in developing novel and cutting-edge products. The 3 different patent categories include: design patents, coverage for an invention's aesthetic appeal. Emojis, fonts, and other distinctive visual characteristics are all covered by ornamental design patents, such as the Coca-Cola bottle's shape. Patents for plants act as safeguards for novel plant species. Fruit trees without pests are an illustration of a plant patent. But if the tree has distinctive visual characteristics, inventors could also require a design patent. Protection for a product that is helpful and serves a practical function is provided by utility patents. Examples of IP include software, pharmaceuticals, and auto safety systems. The initial and still largest field of patent law is this one. 2. Brand names. The use of logos, sounds, words, colors, or other symbols by a business to distinguish its goods or services is protected by trademark law. The Twitter logo, the McDonald's golden arches, and the font that Dunkin' uses are all instances of trademarks. While trademarks may cover a range of goods, patents only protect a single product. Trademarks, trademark infringement, and service marks are all governed by the Lanham Act, often known as the Trademark Act of 1946. 3. Copyrights. The rights of the original creators of original works of intellectual property are safeguarded by copyright laws. Copyrights, unlike patents, must be observable. For example, ideas cannot be protected by copyright. However, you can obtain a copyright and record an original speech, poetry, or song. When an original work of authorship, OWA, is produced, the author instantly acquires the copyright. 4. Business secrets. Trade secrets are private, valuable, and informational intellectual property that belongs to a business. They could be a formula, recipe, or method utilized to gain an advantage over rivals. Companies must actively attempt to preserve proprietary information in order for it to qualify as a trade secret. Trade secret laws no longer apply to information that has become public knowledge. Assets may be tangible or intangible, and information that is a trade secret may include any of the following, as stated in 18 U.S.C. 1839(3). Business, financial, technical, economic, scientific, engineering. The formula for Coca-Cola and Google's search algorithm are 2 well-known examples. Trade secrets, in contrast to patents, are only accessible by the owner. What are a few examples of intellectual property violations? Infringement, counterfeiting, and misappropriation of trade secrets are the main intellectual property crimes. Intellectual property violations include designing a logo or name with the intention of duping consumers into believing they are purchasing the original brand, unauthorized video or music recording, as well as copying intellectual property, yes, even on a photocopier, for private use. Copying a patent and selling it as your own while doing so. Making patented products without a valid license. Intellectual property affords numerous protections comparable to real property ownership because it may be purchased, sold, or leased. Likewise, there are similar treatments. The resolution of a disagreement may involve the seizure of property, the assessment of monetary damages, or cease and desist orders. Which types of laws governing intellectual property rights are valid in India? The following list includes the many categories of intellectual property rights laws recognized in India. The 1970 Patents Act, the 1957 Copyright Act, the 2000 Designs Act, the 1999 Trademarks Act, Act of 1999 Registering and Protecting Geographical Indications of Goods, Act of 2000 concerning Semiconductor Integrated Circuits Layout Design, Act of 2001 Protecting Farmers' Rights and Plant Varieties, 2002's Biological Diversity Act. MSMEs, micro, small, and medium enterprises, are essential to India's economy. Today, MSMEs play a significant role in the supply chain for goods and services. As a result, MSMEs significantly increase employment while promoting India's rural areas' modernization and industrialization. The Government of India has introduced a number of initiatives and programs that are expressly intended to boost MSMEs in response to the realization of the importance of MSMEs for the Indian economy. For instance, the Make in India project was launched to strongly encourage and provide incentives to MSMEs. Like any other firm, MSMEs have a number of resources that are crucial to their unique business strategies. Novel innovations, an MSME's brand name, or an industrial design may all fall under this category. Therefore, it would be accurate to state that intellectual property rights, IPRs, would need to play a crucial role in order to secure these assets, which are extremely important to MSMEs. MSMEs are constantly working to develop innovations, brand identities, and trade secrets that need to be secured due to the fierce competition seen in today's changing business contexts. This could mean, for instance, that IPRs would be crucial for safeguarding brand recognition and logos through trademark registrations, protecting inventive works with the aid of patents, and safeguarding attractive designs by legally registering the design, giving the MSME some level of exclusivity in a cutthroat market. The significance of IPR for MSMEs has often been acknowledged by the Indian government. After then, a number of programs and efforts were put into place to encourage MSMEs to safeguard their intellectual property, IP. The government lowered the cost of submitting an IPR for MSMEs in 2019. This included lowering the costs by 60% and 50%, respectively, of filing for a patent and a design. The costs for filing trademark applications were also lowered by 50%. The Bilateral Patent Prosecution Highway Program, which would speed up the patent application procedure, has also been introduced by the government. There will be less money required to file intellectual property claims, according to Piyush Goyal. Protecting your company's intellectual property has various advantages, particularly if it is an MSME. MSMEs who want to grow their firm significantly are recommended to take extra precautions to preserve their intellectual property, IP, since doing so may result in licensing deals with larger corporations in the near future. The following are reasons why MSMEs should protect their intellectual property. Exclusivity versus protected IP. Legal protection of one's brand and related assets is essential in a cutthroat industry. For any firm that wants to grow, brand recognition is essential. Corporate oligopolies spend millions on IP protection for the same reason. Similar to this, if an MSME wants to grow its firm, it must unavoidably think about investing in IP protection due to its many benefits. This may involve safeguarding an M.S.M.T. trademark, copyrights, or patent rights while they are still in their infancy. By defending an MSME's intellectual property, the owner is granted sole ownership. Here, the MSME owner would be the exclusive owner of his or her intellectual property. As a result, the IP owner would have access to a wide range of legal remedies if another party tried to use the MSME's intellectual property without authorization. This might deter several other rivals from attempting to steal the business plan, the technologies, or the ideas of an MSME. Advantage over rivals. A competitive advantage could come from protecting an MSME's intellectual property. For an MSME to pursue growth and expansion, a competitive advantage is essential. For instance, obtaining a trademark for an MSME's goods or services may demonstrate the high caliber of such items or services. Customers would develop a sense of trust and goodwill for the brand as a result. Additionally, it might boost customer loyalty. In order to differentiate an MSME from other companies in a similar field, it is therefore a good idea to preserve its intellectual property. Additionally, the preservation of an MSME's intellectual property may subsequently prove to be beneficial to their company. MSME owners can profit financially by licensing, selling, assigning, or franchising their intellectual property after properly registering it. For instance, if an MSME develops a patentable breakthrough, they might reveal the invention to potential investors who might be interested in investing in the MSME and perhaps even license the patent. An MSME's growth could be considerably accelerated by this. GI product manufacturers who are MSMEs are given legal protection. Geographical indications, GIs, are indicators used on particular items that have distinctive traits that come about as a result of coming from a particular place. Salem fabric, Chanderi saris, Nora rice, Darjeeling tea, and Mysore silk are a few of the most renowned GIs in India. MSMEs produce the majority of GI products. Giving a product made by an MSME a GI tag could make trade-in easier in a variety of ways. For starters, this might enhance the brand recognition and reputation of that product, which might increase the profitability of an MSME that produces a good with a GI tag. Additionally, by obtaining a GI tag for a well-known regional product, the MSME may also pursue legal action against companies who counterfeit the product and market non-original versions of it on physical or digital media. Committing funds to additional research and development. The growth of an MSME depends on ongoing research and development, which could be stimulated by protecting an MSME's intellectual property. For instance, a patent holder may use his or her innovation for economic gain. As a result, they receive some recognition for their innovation and generate more income that could be reinvested in the MSME. This investment can be used for research and development, which could help an MSME advance its innovation and, ultimately, experience growth. Overall, it can be said that IPR is extremely significant for MSME businesses. By defending one's intellectual property, an MSME may eventually expand. This expansion is made possible by a competitive edge that IPR might offer, exclusive rights to protected intellectual property, legal protection for GI products, and spending money on more research and development, to name a few. It might be anticipated that more MSMEs may start to defend their IPs as a result of the Government of India's persistent encouragement of MSMEs to do so through fee relaxations and programs, which could ultimately contribute to the country's economic growth. What are India's IPR law landmark judgments? The following are the significant rulings on intellectual property rights in India. Legal IPR in India. TVS Motor Company Limited v. Bajaj Auto Limited, JT 2009, 12 SC 103. The IPR law in this instance is concerned with a patent dispute over the use of twin-spark plug engine technology. In one of its landmark decisions on IPR law in India, the Supreme Court of India, SC, has ordered all Indian courts to expeditiously hear and decide cases involving intellectual property, IP, in their respective jurisdictions. This case involves a 2-year-old patent battle between two major corporations over the use of twin-spark plug engine technology. The Supreme Court, SC, of India noted that disputes over temporary injunctions are a major point of contention in cases involving trademarks, patents, and copyrights that have been lingering for years. The final verdict connected to a case should normally be provided within 4 months of the day the complaint was filed, according to a directive from the Supreme Court that the hearing in intellectual property cases in India be conducted on a daily basis. The Supreme Court, SC, of India also ordered all tribunals and courts operating within its borders to sincerely and promptly execute the aforementioned orders. Akash Arora and others v. Yahoo Incorporated, 1999, 19, PTC 201, Del. The protection of intellectual property rights on the Internet is addressed by one of the first landmark judgments on IPR law in India. The Delhi High Court, HC, held that a domain name is entitled to equal protection because it performs the same purpose as a trademark, which is considered to this day as one of the landmark judgments on IPR law linked to cybersquatting. In this case, Yahoo, the domain name of the plaintiff, and Yahoo India, the domain name of the defendant, were almost phonetically same and comparable. In such a scenario, there was a very real risk that Internet users who were using the plaintiff's domain name would get confused and tricked into thinking that the defendant's and plaintiff's domain names shared some sort of origin or link. The Delhi High Court further stated that it was irrelevant that the domain name Yahoo is a dictionary word because the nature of the Internet precludes the use of similar or identical domain names, and that the defendant's use of a disclaimer was insufficient in this case. When the name Yahoo was connected to the plaintiff, it gained distinction and uniqueness. In the case of Rediff Communication vs. Cyberbooth and Dar, 2000 PTC 209, the Bombay High Court, HC, further noted the significance and value of a domain name as a competitive advantage for a business. Union of India v. Bayer Corporation, 162 2009 DLT 371. In the case of Bayer Corporation v. Union of India, an inventive writ petition can be filed in the Delhi High Court, HC, in lieu of filing an infringement lawsuit, requesting that CIPLA's approval of marketing application under the Drugs Act not be entertained or processed because CIPLA's Supremediq applications allegedly infringed the plaintiff's patent. For the first time, an effort was undertaken to connect the clearance of a medicine to Indian patent infringement. The Delhi High Court, HC, in contrast, disapproved of the injunction and imposed a steep fine of 6.75 lakh rupees to stop any such efforts. A combined reading of Sections 2 of the Drugs and Cosmetic Act and 48 of the Indian Patent Act, 1970, according to Bayer Corporation, creates a mechanism known as patent linkage that forbids the market from approving the sale of a drug if a patent already exists for that same drug. Additionally, according to the Bayer Corporation, Supremediq is a spurious drug as defined by the Drugs Act of 1940, and as such, market approval cannot be granted. The Honorable Delhi High Court, HC, of India ruled that because the goals of the two acts are unlike, there is no such drug patent linkage system in the country of India. In accordance with both acts, the Patent Act of 1970's Controller of Patents has sole jurisdiction to establish patent standards. Additionally, the patent linkage will have a negative impact on India's public health policy. The Delhi High Court also ruled that approving a medicine for sale does not violate a patent. Therefore, it is necessary for the patent infringement to be proven in a court of law rather than being presumed. The drug authorities lack the authority and capacity to make such a decision. The Delhi High Court ruled that Supremediq medicine does not fall under the category of counterfeit goods because there is no element of passing off, such as imitation or deception, present in this Cipla product. Gufic Limited and R.V. Clinique Laboratories LLC and others, Manu/Day/0797/2009. In this instance, a registered trademark owner has filed a lawsuit for infringement against a registered trademark holder. The parties involved in this case's current disagreement were the plaintiff and defendant's respective registered trademarks. It is quite noteworthy to note that the plaintiff Clinique had filed a petition for cancellation against the defendant Gufic Limited before the Trademarks Registrar of India prior to the filing of the lawsuit for infringement, asking for the cancellation of the defendant Clinique trademark. Any lawsuit may be postponed in accordance with Section 124(1)(2) of the Trademarks Act, 1999, pending the outcome of the competent authority's decision on the petition to cancel the trademark. However, the court has the power to issue an interlocutory order, including orders issuing interim injunctions, appointing receivers, maintaining accounts, or attaching any property, in accordance with the provisions of Section 124(5) of the Trademarks Act, 1999. In this instance, the court decided that one registered owner of an identical or similar brand might be sued for trademark infringement by another registered owner. This case is regarded as one of the landmark rulings on intellectual property rights in India. The court was further instructed that in this instance, under the condition that it is prima facie convinced that the defendant's trademark registration is invalid, it may issue an interim injunction to prevent the defendant from using the registered trademark while the proceedings are stayed pending a decision on the defendant's petition for rectification or cancellation. In this instance, a temporary injunction was issued in the plaintiff's favor pending the competent authority's decision on the petition for cancellation. In Re Union of India, Novartis, Civil Appeal Numbers 2706 to 2716 of 2013, formed as a result of SLPC numbers 20539 to 20549 of 2009. One of India's landmark decisions pertaining to IPR law is this one. The issue concerns the denial of a patent for a drug that was neither inventive nor effective enough. In accordance with the definition of innovation as stated in Section 3 of the Patent Act of 1971, the company Novartis registered a patent application for one of its medications, Gleevok. After a 7-year legal fight, the Supreme Court, SC, of India denied Novartis' motion. The Supreme Court, SC, gave the following justifications. There was no novel drug invented, and according to the Patent Act of 1970, the discovery of an already known drug does not qualify as an invention. The Supreme Court of India endorsed the idea that under the Patent Act of 1970, for the grant of pharmaceutical patents in India, there is a new test of improved therapeutic efficacy for claims that cover some incremental changes to already existing drugs, for which the Novartis's drug also did not qualify, in addition to proving the traditional tests of inventive step, novelty, and application. Because the Supreme Court, SC, looked above the formalities and into the fact that all of these corporations were attempting to evergreen their separate patents and make them unaffordable at some minimal rates, this case became one of the landmark judgments on IPR law in India. Conclusion. Every industry relies heavily on intellectual property rights, which are also the foundation for critical investment decisions. It can be difficult to strike a balance between the interests of society and inventors because intellectual property rights are exclusive rights granted to the owner of intellectual property. A sound legal framework is crucial for protecting the interests of inventors and fostering their trust that their intellectual property will be safeguarded, which will spur more invention. Due to the huge number of courts, the inconsistent level of understanding of judicial officers in areas pertaining to intellectual property rights, and the inconsistent methods of practice, intellectual property rights litigation is highly diverse in India. As a result, India has established a number of landmark IPR judgments that continue to this day to assist in resolving important problems in the same field. Some courts are selected over other alternative forums for the identical concerns regarding intellectual property rights and render some extremely significant landmark judgments on IPR law in India due to the varying understanding of the judicial officers. Government of India Initiative on Intellectual Property Rights. To advance the IP regime, the government recently released the National IPR Policy. The strategy will promote entrepreneurship, creativity, and innovation in India. It will prevent someone else from stealing someone else's innovation. India's first IPR policy is this one. The Credit-Linked Capital Subsidy and Technology Upgradation Scheme, CLCS2s, is a Government of India initiative under the MSME. The scheme's seventh element, building awareness of intellectual property rights, is one of the 7 parts, IPR. One of the major factors determining whether an innovation succeeds on the market is intellectual property, IP. IP significantly improves the competitiveness of technology-based enterprises and makes it easier to introduce new technologies to the market. Issues with intellectual property rights, IPRs, have become extremely important for the sustainability of micro, small and medium enterprises in today's highly competitive global economic environment, MSME. IPR protection is essential for gaining a competitive edge and advancing technology in order to compete with global standards and technical difficulties. This is because IPRs are critical tools for fostering marketing and innovation. Regarding the policy, the policy's slogan is Creative India, Innovative India. This is done to discourage the production and selling of fake goods and to encourage entrepreneurship, creativity, and innovation. Intellectual property encourages advancement in S&T, the arts and cultures, traditional knowledge, and biodiversity resources. Knowledge is the primary driver of development, and knowledge owned is transformed into knowledge shared. This promotes an India where creativity and innovation are encouraged by IP for the benefit of all. It establishes a formal system for implementation, oversight, and evaluation. It tries to adopt and modify best practices from around the world for the Indian context. IPRs in India are being implemented and will continue to develop under the direction of the Department of Industrial Policy and Promotion, DIPP, Ministry of Commerce, Government of India. Visit the linked page to learn more about the Department for Promotion of Industry and Internal Trade, DPIT. The WTO's agreement on trade-related aspects of intellectual property rights is upheld by India's IPR regime, TRIPS. The national IPR policy's goals are to be carried out by the Cell for IPR Promotion and Management, CIPAM, which was established under the supervision of DIP. The IPR policy's goal. There are 7 main goals. IPR, outreach, and promotion, raising public understanding of I.P.R.'s positive effects on the economy, society, and culture. Encourage the creation of IPRs by cultivating an environment that is inventive and innovative. Replace obsolete rules with strong, effective IPR laws that combine the rights holders' interests with broader public interest. Human capital development for intellectual property education, research, and skill-building. Human resources, institutions, and capacities are strengthened and expanded by rights. Modernize and improve service-oriented IPR administration through administration and management of innovation. IPR commercialization. Commercialization can be used to maximize IPR value. Strengthening the enforcement and adjudicative processes to combat IPR infringements. Strengthening the enforcement and adjudicative processes to combat IPR infringements. The policy established a legal framework that will support the IPR regime and shorten the time it takes for a trademark to be approved by the government to 1 month. At the moment, the procedure takes longer than a year. An IPR policy is required. It is crucial for the government to offer incentives in the form of tax breaks in order to promote research and development. The U.S. Trade Representative, USTR, kept India on its priority watch list in its annual Special 301 report on the global state of IPR protection and enforcement for the 2016 edition. To protect innovations so that there are less legal disputes in this area. It will aid in preserving Indian traditional knowledge. It will contribute to the improvement of the Startup, Make in India, and Digital India programs. Important details. It aims to preserve the public interest while promoting innovation and entrepreneurship and realizing intellectual property rights as a marketable financial asset. The policy will be revised every 5 years. The strategy complies with the TRIPS agreement made by the WTO. A special emphasis is placed on raising awareness of IPRs, their effective enforcement, and the promotion of IPR commercialization through incentives. India will negotiate international treaties and accords after consulting with relevant parties. The Department of Industrial Policy and Promotion, DIPP, should serve as the focal point for all IPR matters, the report suggests. Issues pertaining to copyrights will also fall under DIP. By 2017, it is the goal of a number of trademark offices to cut the time needed for assessment and registration to only 1 month. There will also be copyright protection for things like movies, music, and industrial drawings. The whole value chain from the generation of IPRs to commercialization is intended to be made easier through domestic IPR filings. Through tax advantages, it attempts to encourage research and development. There is a plan to establish a successful loan guarantee program in order to support new businesses. The policy grants the GOI legislative flexibility under the international treaties and TRIPS agreement, allowing it to use clauses like Section 3D and compulsory licensing, CLs, to guarantee the accessibility of necessary and life-saving medications at reasonable costs. The government will consider ratifying some multilateral agreements that are in India's best interests and will sign those agreements that India has already de facto ratified in order to participate in the decision-making process. The proposed IPR policy regime has the following benefits. It is a vision plan that seeks to build connections among all types of intellectual property, relevant laws, and government organizations. It would harmonize India's IP regime with international standards and raise India's ease of doing business score on the World Bank. The policy promotes investments in India by potential investors and strategic partners while ensuring credibility. It will decrease the amount of time needed to process the backlog of IPR applications. It works to improve access to healthcare, food security, and environmental protection while preventing the piracy of movies and music. A stable, open, and service-oriented IPR administration in the nation is made possible by policy, which also encourages creativity and innovation across industries. It will raise awareness, which will contribute to creating a culture that supports innovation and creativity and produce commercially viable, protectable intellectual property industry, and people would gain from the Copyright Act and Semiconductor Integrated Circuits Layout Design Act being brought under DIP. Due to better administrative convergence, the commercial relevance of IPRs will be better affected when they are housed under one roof. All facets of society are to be made aware of the social, economic, and cultural benefits of IPRs. Drawbacks. The Doha Declaration on World Trade Organization, WTO, TRIPS, trade-related IPR agreement, and public health is a commitment made by India, according to the IPR policy. However, there was some concern that the inclusion of the Doha Declaration and flexibility would lead to attempts to undermine TRIPS in order to benefit pharmaceutical firms. In the absence of financing and programs to enable universal access to healthcare, any change in the legal system would be detrimental to both the generic industry and the Indian populace. Traditional knowledge and the informal creativity/innovations based on it are not addressed in the policy. Absence of proof supporting the value of current trade secret and utility model legislation in fostering unofficial innovation. Even while it claimed that the primary responsibility for securing IP rights was on the IP owner, it envisions significant government investment for protecting and promoting foreign IP in India. Furthermore, the mention of state laws in the context of copyright protection demonstrated how the policy was biased in favor of IP owners rather than society. Few experts believe that the national IPR strategy is insufficient for promoting innovation since it lacks specificity. It presupposes that greater IP leads to greater innovation. It fails to comprehend that IP is merely a means to an end and not an end in and of itself. Corporates have also acknowledged that certain technical industries, where a free flow of open knowledge is more appropriate, do not work well with IP. Experts are also dubious about the policy's application to the rural informal economy. Because rural economies and creativity are not well understood. In rural places, adopting a formal IP policy may cause more harm than good. Last but not least, making violations of the Indian Cinematograph Act illegal is excessively harsh and unjust. IP wrongs are essentially civil wrongs, so they shouldn't be made illegal. Results of the new IPR policy. Ranking improvement. India's position in the WIPO-issued Global Innovation Index, GII, rose from 81st in 2015 to 48th in 2020. Increase in patent and trademark filings. Compared to the same period in 2017-18, patent filings climbed by about 7% in the first 8 months of 2018-19. Over this time, there has been an almost 28% increase in trademark filings. enhancing institutional mechanisms for promoting and protecting IP, clearing backlogs/decreasing pendency in IP applications. The government's increase in technical manpower has led to a significant decrease in the amount of time that IP applications are pending. Another innovation is the automatic issuance of electronically created patent and trademark certificates. Processes have been streamlined and made more user-friendly in accordance with the IP Process Re-engineering Patent Rules, 2003. Trademarks rules have been updated and announced in 2017. IPR awareness programs having been conducted for industry, police, customs, and judiciary as well as in academic institutions, including rural schools through satellite communication. Centers for Technology and Innovation Support, TISCs. TISCs have been set up in numerous universities across various states in conjunction with WIPO. The next step and the conclusion. The IPR's policy would go a long way toward encouraging the Indian sector to develop as well as to preserve and enforce their innovations, but other areas still need more examination, such as the idea of information sharing and knowledge access. The expansion of the innovation ecosystem with improved IPR protection is necessary for the success of India's flagship initiatives, Make in India and Startup India. The expansion of the protection to include items that are in the public domain is also causing some worry. More foreign investment in the nation could be attracted with better policy enforcement. It appears that the policy's approach to copyrights and trademarks is designed to meet the interests of foreign businesses. They will be more motivated if rights are granted more quickly and are strictly enforced. The policy's approach to digital piracy, which suggests harsher measures for addressing the problem, is one of its main features.